You have the right to remain silent. We've all heard it, right? It's practically baked into our brains from every crime show ever. We think of it as this absolute bulletproof shield against the law. But is it really? What actually happens when you decide to zip your lips? Welcome to This Explainer. Today, we're going to flip some of your biggest assumptions about the right to remain silent right on their head, and we'll see how saying literally nothing can sometimes speak volumes to a judge or a jury.
Okay, here's our roadmap for today. We'll cover the origins of the right to silence, unpack a really tricky legal concept called adverse inference, see how international law protects this right, and then dig into the surprising legal shifts in the UK and the US.
Section 1. The right to silence, from Roman origins to the Miranda warning.
Picture this. You're sitting in a cold, high-pressure interrogation room. Questions are flying at you, and you're relying entirely on your right to just say nothing. But where did you actually get that right? To figure that out, we've got to go way back, because this fundamental protection isn't some new invention. It's an ancient concept born in Roman law. They called it nemo contra se perdere tenetur, which translates to, "Thou shalt not compel anyone to oppose his action." Basically, it laid down the foundational idea that you shouldn't be forced to be the instrument of your own legal downfall.
But history played a bit of a ping-pong match with this right. The Romans had the right idea, but then things took a seriously dark turn during the Middle Ages. Back then, the right to silence was totally crushed. A spoken confession was considered the absolute king of evidence. And to get that confession, courts routinely relied on barbaric torture. Suspects essentially had zero human rights. Thankfully, the 18th century Enlightenment movement flipped the script, heavily inspired by the 1641 abolition of the UK's incredibly oppressive Court of Star Chamber. And that eventually led to the 1898 UK Criminal Evidence Act, which firmly cemented the right to silence in criminal procedure. Moving right along to Section 2, what is adverse inference? When silence is used against you. So, this brings us to a massive legal curveball. We know you have the right to be silent, but what if your silence actually hurts you? Is staying quiet really a consequence-free shield? Just think about it for a second. If you are 100% innocent and you have information that could quickly clear your name, wouldn't you want to shout it from the rooftops? Well, that natural question leads us straight into a concept called adverse inference, or sometimes the empty chair doctrine. An adverse inference is a legal conclusion drawn by a court that is unfavorable or adverse to the accused, and it's made specifically because the accused stayed silent or failed to provide requested evidence that they clearly had control over. The logic here is pretty fascinating. It operates on the presumption that if you have evidence that could help you, but you refuse to produce it, you're probably trying to hide something bad. Simply put, the court can tell the jury that your silence might actually mean you've got something to hide. Which brings us to Section 3, International Law Protections. Silence as an absolute shield. Now, let's zoom out and look at the global stage. On an international level, the right to remain silent is treated like an almost absolute shield. Following World War II, international law took a super strict stance against adverse inferences. Major human rights pillars, like the 1948 UN Universal Declaration, Article 14 of the International Covenant on Civil and Political Rights, and Article 8 of the Pact of San Jose, they all firmly protect people from being forced to testify against themselves. And it goes even further. At the Hague International Criminal Courts, like the ICTY and the ICC, the systems heavily protect the right to silence. They absolutely refuse to allow adverse inferences to be drawn, treating a suspect's refusal to speak as a fundamental human right, totally free from any negative legal assumptions. Now for Section 4, the United Kingdom's shift. The birthplace of the right changes its mind. Okay, here's where the story takes a really fascinating turn. To fully appreciate the irony, we have to talk about a 17th century British citizen named John Lilburne. Lilburne was arrested for unlicensed publishing and dragged before that infamous Court of Star Chamber we mentioned earlier. He bravely refused to take their oath, arguing that he wasn't bound to incriminate himself. And for a silence, Lilburne was whipped and locked in the pillory. But his suffering sparked massive public outrage, which ultimately led to the abolition of the Star Chamber and birthed the right to silence in English common law. So for centuries, the UK proudly protected this strict right to silence. It was sacred. But then a dramatic shift happened in the 1980s. Why? Well, the political reality on the ground changed. Facing a wave of terrorist attacks in Northern Ireland, the UK leaned heavily towards national security. They passed the 1988 Northern Ireland Criminal Evidence Order and the 1994 Criminal Justice and Public Order Act. And just like that, these acts swept away the absolute shield. They explicitly allowed courts to draw adverse inferences if a suspect failed to mention facts, answer questions, or explain why they were at a crime scene.
But I should clarify, it's not a total free-for-all. The UK's use of adverse inference is highly structured. In a landmark case called R.V. Argent, Lord Bingham laid out 6 very specific conditions that absolutely must be met before a court can use your silence against you. There have to be formal proceedings. The failure to speak must happen before or on charge, during questioning under caution, and while the police are actively trying to discover the offender. But here's the crucial part. The accused must later rely on a fact in their defense that they failed to mention earlier, a fact that any reasonable person would have naturally brought up at the time. So it requires a very specific failure to account for things like objects, marks, or your presence at the scene. On top of that, the UK set up strict boundaries to prevent the system from being abused. Even with this massive shift, a judge cannot draw an adverse inference in a bunch of specific scenarios. For instance, if the accused simply didn't know the facts at the time, or if the police had already made up their minds to charge the suspect, which means questioning legally should have stopped anyway. They also protect suspects if the case is just too old or too complex for someone to give an immediate, sensible response. An inference is also off the table if the accused's physical or mental condition makes it undesirable for them to testify, or if they didn't have access to legal advice during early terrorism interrogations. Now, here's what's truly wild about this. How did the international community react to the UK's controversial new laws? Well, in 1996, the European Court of Human Rights ruled on an appeal in a case called Murray v. the United Kingdom. Murray argued that these adverse inferences completely violated his right to a fair trial. But, plot twist, the European Court actually upheld the UK law. They ruled that drawing a quote-unquote reasonable inference from a suspect's silence does not inherently violate the right to a fair trial under the European Convention on Human Rights. That was a massive validation for the UK's new approach.
Finally, Section 5, the United States approach, the Miranda warning and its limits. All right, let's cross the Atlantic and see how things work in the U.S. The American right to silence is anchored right in the Fifth Amendment of the Constitution, and it was radically shaped by one of the most famous Supreme Court cases ever, the 1966 case Miranda v. Arizona. This landmark ruling established the Miranda rule, meaning suspects absolutely must be explicitly informed of their rights prior to interrogation if their statements are going to be used to prove their guilt in court. This is exactly why every single one of us knows the phrase, "You have the right to remain silent." And this brilliantly illustrates the nuance of U.S. law, or what we might call the rule of exceptions. It's a delicate balancing act. On one hand, Miranda v. Arizona dictates that un-Mirandized confessions cannot be used to prove you are guilty. But on the flip side, in a case called Harris v. New York, the Supreme Court established that if you take the stand and testify, your past un-Mirandized statements can be brought into court, not to prove you're guilty, but to impeach your credibility and prove that you're lying on the stand. This exact standard was later re-emphasized in James v. Illinois. So while your silence protects you from forced self-incrimination, you absolutely cannot use that protection as a license to commit perjury on the witness stand. But here is the crucial takeaway. Despite these exceptions regarding credibility, the U.S. Supreme Court fiercely guards the core of the Fifth Amendment. In the 1999 case Mitchell v. United States, the court laid down the law, ruling that a judge absolutely cannot draw a negative inference from a defendant's silence during the sentencing phase of a trial any more than they could in the initial trial phase itself. In the U.S., your silence remains your right from start to finish. So we've seen how international courts treat silence as an absolute shield, how the UK allows strict adverse inferences to combat terrorism, and how the US balances the Fifth Amendment against the need for courtroom honesty. And that brings us to one final thought for this explainer. In the incredibly delicate balance between national security, the court's relentless search for the truth, and your own fundamental human rights, is silence truly golden, or does saying nothing sometimes say absolutely everything? Thanks for joining me as we explored the fascinating limits of the right to remain silent. Keep questioning and keep learning.